Attorney General for the state appellants. I would like to reserve 3 minutes for rebuttal.
3 minutes.
Thank you, Your Honors. And Your Honors, details matter. If I go to a car dealership and I ask for a red 4-door convertible, not any red car will do. But here Erlanger is saying, well, we think that our car is red, and therefore you should buy it. Here, the General Assembly has passed a law, Tennessee Code 715108, which we've called the state DRA, which has 3 distinct requirements. It has to be consistent with federal law and approved by CMS, which the SPA rates and the rural rates are. That it has to be the average contract rate that would apply under the state plan, which the SPA rates and the rural rates are. And it has to be budget neutral relative to the payments made to out-of-network providers prior to January 1st, 2007. Here, again, the SPA rates and the rural rates are. We've briefed many reasons why the court should reverse the district court and grant judgment in favor of the state appellants. I'd like to focus on 3 today. First, this is a question that should be taken up by CMS in the first instance. Second, as indicated, the state plan amendments and rules meet all of the requirements set out by the General Assembly and the state DRA. And third, the General Assembly authorized Tenncare to control costs, notwithstanding any other state law to the contrary. On the CMS question, I think that's important because about two-thirds of what the Tenncare budget is paid by the federal government. And if we are not doing what's in our state plan, then the federal government can withdraw its funding. And that's undisputed. In fact, Erlanger says it's in its own briefing that if Tenncare does something other than what's in the state plan, then CMS can withdraw its funding. And that's an issue of federal law, that Tenncare has to pay the rates that are determined in accordance with the standards in an approved state plan. Here, CMS approved the rates. There's no question of that. And so therefore, we satisfy that aspect of it. And I think that's important, Your Honor, because that goes to whether Tenncare can buy the convertible in the first place, because we've got someone who's helping us pay for it. Second, the first sentence as to the state DRA, the first sentence requires that any payment methodology be consistent with the federal DRA and approved by CMS. Here it is. And I think that's an important point because first, not only do we have to comply with the federal DRA, but also we have to comply with all of these other requirements that come with Medicaid. An important one of those is network adequacy. And the short way of thinking of network adequacy is the state incentivizing providers to join the network or to not join the network? Here in the administrative proceedings, the commissioner's designee made an unrebutted finding that if Tenncare were to adopt Erlanger's construction, that we wouldn't have network adequacy because people who are being paid below, people who are in network and are being paid below the average network rate would then say, well, hey, I'm getting a raw deal here. And so I should get out of network and then I can get an average rate instead of this lower than average rate. And second, Your Honors, this goes to the second sentence, which says the average contract rate is the rate that would apply under the state plan. That language is both in the federal statute and the state statute. In fact, Erlanger's brief on page 27 says both statutes address the same subject matter with the same language. And the court found that
Is that what the state's doing, though?
Yes, Your Honor.
Is that, I had the impression, correct me if I'm wrong, and I'm sure you will, that there was the state gathered information on actually lower rates and then averaged those lower rates somehow.
Well, that's the question, Your Honor, is which of the contracts you're looking at. So under the contractor risk agreements, which are the contracts that we say the court should look at, the MCOs, and these are contracts between the MCOs and the state. Under those, the MCOs say that they will pay the lowest rate that they pay to any in-network provider.
Okay.
And we average those rates. And I think this is an important point because those are contracts. No one disputes that the contractor risk agreements are contracts. Erlanger on page 39 and footnote 8 of its brief acknowledges that those rates are rates that are under the state plan, and no one disputes that Tenncare averaged the rates of those contracts. So even under Erlanger's briefing, we meet all of the requirements of being average rates under the state plan.
Correct me if I'm wrong, but it just appears to me that it's not the plan that the chancellor objected to. It was the procedure in establishing that plan. Am I wrong about that?
So, Your Honor, the court did, the court addressed both of those. So it said both the plan and the procedure. I'm happy to address the procedure if you would like. So I think on the procedural question, there are two issues. So first is under the rules, the question is whether Tenncare was required to cite the state DRA in its rulemaking form. There's been no court, Erlanger doesn't cite any court, we're not aware of any court that has invalidated a rule based on a rulemaking form, because where the Secretary of State has approved it, that's who the law gives the right to approve it. And the court has said that we shouldn't focus on rigid formalism. So here, where the Secretary of State approved the rule as citing all of the necessary statutes, that should be sufficient. The second question is as to the state plan amendments, whether they should have gone rulemaking first. But, Your Honor, they can't, because they're federal law. And that makes them statements of federal the Centers of Medicaid Services, not of Tenncare. And so if we were in a situation where we had to do rulemaking and then do a SPA and then do rulemaking again because there's negotiating, you would completely ossify the Tenncare process, and we wouldn't be able to do anything or certainly act quickly to respond to demands of the federal government.
Were they at least done as emergency rules? And then later on went through the rulemaking?
Your Honor, the 57% rate one was done as an emergency rule first, and the 74% was not.
Okay.
And on the third point, Your Honors, as to the statute, I think that this is an important, the General Assembly specified that whatever the rate was, it had to be budget neutral compared to what the out-of-network providers were being paid prior to January 1st, 2007. Well, here, that's what Tenncare did. They took the rates that were being paid, they figured out a way to average those, and that's what they're paying. Under Erlanger's construction, Erlanger admits that it would require much higher payments to out-of-network providers. So it doesn't meet that. It just says simply, Erlanger's argument is simply, oh, well, we wouldn't have raised the capitation payments. But that's not what the General Assembly required. The General Assembly required it to be budget neutral compared to what the out-of-network providers.
Well, it required it to be budget neutral for the state fiscal year 2007-8. Didn't say anything about subsequent years.
Correct, Your Honor, but under Erlanger's construction, it wouldn't have even been budget neutral for 2007, 2008 using the metric provided by the statute.
Does it, so you're not saying it has to be budget neutral now?
I think,
or are you?
I think, Your Honor, that it says a payment methodology that has to be budget neutral, and it doesn't say multiple payment methodologies, but even if we just look at fiscal year 2007, 2008, Erlanger's construction doesn't satisfy that. So for those reasons, we do satisfy the state DRA. And also, even if the court thinks that there is a question as to whether we satisfy the state DRA, it should nonetheless rule in favor of Tenncare, because the court gave authority to Tenncare to, under 75-102D, it says, Tenncare shall have all such authority to control costs, notwithstanding any other state law to the contrary.
Well, yeah, but I have two questions about that. One, that's in a statute that lists a whole lot of ways you can control costs. 102D lists all kinds of, a whole list of them. I won't go into that because I don't even understand most of them. Yeah. But that last sentence in that provision says to me that it's talking about controlling the Tenncare has all such authority to control the costs, and it's referring to the ways it's already given authority to control it and saying you can do it any way you can. You can do any of these any way you can, rather than it referring to other statutes. But even if that's not right, doesn't 108 prevail over 102 because it was enacted later?
Well, first, Your Honor, let me address your first question. 7102D actually says such cost-saving measures may include but are not limited to. So there's
Okay.
so under 102D's express language, it's not limited to the methods stated here.
Okay.
Second of all, Your Honor, no, 102D has to control here because the state, because it's more specific on the issue of what to do in case of a conflict. If the court were to say simply any other later law overturns 102D, then you're essentially rendering that language useless because that's the standard rule.
Well, that's what the legislature said later, though. It's later and very specific about costs.
Well,
later statutes always prevail over prior statutes to the extent of a conflict, don't they?
Not here, Your Honor, where the legislature expressly stated that this provision should prevail in case of a conflict. In fact, in EMCF, the court said
Well, in
that
case of a conflict with any laws that existed when it was enacted. But they can't stop a subsequent legislature from changing the laws.
You're right, Your Honor, except that here, the question is whether they intended to do that. And I think that we know that they did not intend to do that here, especially when the rules that are at issue here were put in front of the legislature, and the legislature approved those rules in both instances. I see I'm over my time, so I'm happy to, I'll reserve the rest of my time for rebuttal.
Thank you. We'll hear from the appellee. Good morning.
Good morning, Your Honors. May it please the court, Josh Bolian of the Nashville Bar for the appellee, Erlanger. These appeals involve certain payment rates set by Tenncare. The Chancery Court held that Tenncare's rates are invalid for two independently sufficient reasons. That means that in order to reverse, this court would need to hold that the Chancery Court erred as to both reasons. But the Chancery Court did not err as to either reason, much less both. With the court's indulgence, I would begin with the second of the Chancery Court's two reasons. It's the simpler one. It is that Tenncare did not comply with the Uniform Administrative Procedures Act, or UAPA. The UAPA lays out what procedures Tenncare must follow to regulate private parties. If Tenncare did not follow the UAPA, its rates are void and of no effect. The UAPA issue has two parts. One part involves the rates in Tenncare's state plan amendments, or SPAs. That's in appeal number 1619. The other part involves the very same rates as they're written into Tenncare's rules. That's appeal number 1350. For the SPAs in case 1619, the question is whether state plan amendments qualify under the UAPA as rules. This question has come up under similar statutes in 4 other states. In 3 of those states, Illinois, New Hampshire, and Louisiana, courts have agreed with the Chancery Court here. That is, they held that Medicaid state plan amendments are rules. Therefore, without the notice and comment rulemaking required under state law, they are invalid. The 4th state was Mississippi, and it did come out the other way. However, it did so largely by relying on the Louisiana court decision. And that makes no sense because the Louisiana courts ruled our way. Respectfully, this court should join the better reasoned decisions of its sister courts in 3 other states. On that issue, I would add, we heard this morning that were we right about the state plan amendments being rules, then we would be sort of stuck in a procedural vortex where you have to do one procedure and then another and then back to the other. I don't think that would be the case, Your Honor. There's been no argument that the federal requirements for state plan amendments and the state requirements under the UAPA can't be complied with at the same time. It's just that the UAPA imposes some additional procedures that the federal regulation 447-205 does not. Like you have to hold a public hearing, which isn't required under federal law. Tenncare's rules at issue in case 1350 pose a different UAPA question. In making its rules, Tenncare nowhere mentioned the state statute that prescribed what the rates had to be. That is the statute the parties have called the state DRA. This omission renders the rules invalid, and that is because the UAPA required Tenncare to cite all statutes that establish guidelines relevant to its rules. So that is it for one of the Chancery Court's reasons for its holding. Neither the SPAs in the 1619 appeal nor the rules in the 1350 appeal complied with the UAPA. Thus, we submit the Chancery Court correctly held that the SPAs and rules are invalid. The UAPA requires that remedy in section 4-5-216, and this court could affirm on that ground alone. The Chancery Court was also correct to hold Tenncare's rates invalid for a second and totally separate reason. That reason is that Tenncare's rates exceeded the bounds of the state DRA, which is TCA 71-5-108. We heard this morning, before I get to the details of the state DRA, that this is an issue that this court can't even consider because it is a federal issue, because the federal agency, CMS, has approved the state plan amendments. I think that would be news to CMS. State courts have been invalidating state plan amendments on state law grounds since at least the early 1980s, which was the timing of the Illinois decision that's cited in the parties' briefs. And there's been no protest from CMS so far as we're aware. To the contrary, we have in the record a declaration in a North Carolina case from a CMS official indicating that that CMS generally defers to state governments to deal with state law issues. What's more, state plan amendments are not like a regulation imposed on states whether they want them or not. They are rather proposed by the states and then approved by CMS. CMS can't blue pencil them or write their own state plans. So if there was never a valid proposal from Tennessee, then there was nothing to approve here. That is why there can't be federal preemption of the sort that Tenncare urges this court to impose for the first time in the history of the Medicaid program. As to the state DRA, it tells Tenncare what its rates have to be. It says, quote, "The payment amount shall be the average contract rate that would apply under the state plan, close quote. The average contract rate. If Tenncare's rates are anything else, they are invalid. That's undisputed.
Do they not have to be budget neutral?
Yes, Your Honor, they do have to comply with the budget neutrality sentence. However, for the reasons we explain in our brief, they do. The average contract rate that we urge. For one thing, the budget neutrality sentence applies to the budget for state fiscal year 2007-2008. So we're talking about a state budget in 1 year, and we have unrebutted expert evidence that the increase in payments to providers in that year, which was calculated by Tenncare's own assumptions to be only $385,000 in the context of a multi-billion-dollar program, would not have increased the state's payments in that year. In any event, the most that the budget neutrality sentence can do is cap the rates that would have applied in that 1 year, because as the then head of Tenncare, Mr. Gordon, testified at his deposition, which is in the record, the state budget was being worked out at the same time as the state DRA was promulgated, so they didn't want this legislation to affect the budget in that year. Does that answer your question?
Thank you.
So it does have to be budget neutral, but it also has to be the average contract rate. And the truth is that Tenncare never even tried to employ the average contract rate. That is abundantly clear from the record. The then director of Tenncare testified that average contract rate was a meaningless concept. That's on page 1848 of the record in the 1619 appeal. The official who testified on behalf of Tenncare as an agency admitted that, quote, Tenncare chose to do something different than the average contract rate. Page 510. We sent them a contention interrogatory. Tenncare responded that the phrase average contract rate as found in the statute was inapplicable to Tenncare. It's page 1863. This statute says shall be. It has to be this rate. And Tenncare did not even try. Tenncare has so vigorously resisted this language because the phrase average contract rate supports Erlanger. Tenncare was designed to be a market-based program. Rates in Tenncare are set in contracts with healthcare providers. The statute says to take those rates and average them, which is Erlanger's position. In this court, Tenncare stops resisting the phrase average contract rate. Instead, it seeks to reinterpret it. That language, Tenncare says, is a convoluted way to tell Tenncare that the rates it had previously imposed by regulation are the rates that should continue. The crux of Tenncare's new interpretation is that the word contract refers not to contracts with healthcare providers, but to contracts with Tenncare itself. Those contracts do not specify rates, as one would typically think of them, but they do direct the insurance companies to comply with Tenncare's existing rate regulations. This new interpretation cannot be squared with the statute. Everywhere else the state DRA uses the word contract, it means the provider contracts. Tenncare doesn't dispute that. And that is not all that matters. The state DRA got its language from the federal statute called the federal DRA. And the federal DRA also clearly uses the word contract to refer to these provider contracts. It says that the average contract rate applies where rates are, quote, negotiated by contract. Negotiated. The provider contract rates are negotiated, and the rates Tenncare relies on are not. They were imposed by regulation. Now, the state DRA does also say that the average contract rate is one that would apply under the state plan. Does that include the provider contract rates that the Chancery Court relied on? Absolutely. Tenncare is emphatic that the Tenncare program must comply with the state plan in order to secure federal funding. So it follows that the backbone of the program, the provider contracts, also have to comply with the state plan. That means they're governed by the state plan. That is what under the state plan means. Tenncare's rates undisputedly did not average the provider contract rates, so they are at odds with the state DRA. That was the Chancery Court's second and sufficient ground for invalidating these rates. To wrap up, the Chancery Court's holding rested on two grounds, the UAPA and the state DRA. To reverse, this court would have to reverse on both grounds, and the Chancery Court got both right. I could make one final point. There is a citation that is not in our briefs, but it is in Tenncare's. We heard this morning that the General Assembly approved Tenncare's rules, and that in Tenncare's view, that supports Tenncare's interpretation of the statute. Every one of Tenncare's appeal briefs cites the session laws by which the legislature approved these rules and others in that year. But that approval legislation undermines this argument of Tenncare's. Section 1B of the legislation says that the approval should not be taken as proof that the rules comply with every requirement in the Tennessee Code. And that's exactly what Tenncare is asking this court to understand it to be. With that, I'm pleased to answer any questions the court may have.
Hearing none, Mr. Bolian, thank you.
Thank you, Your Honor.
General Smith, your rebuttal.
Thank you, Your Honors. On the procedural point, as to the rules, the Erlanger is asking you to be the first court to say that a rulemaking form the Erlanger is asking you to hold that where the Secretary of State has approved a rulemaking form, and that is who under the law determines whether the requirements of the rulemaking form are met. That if he says that it is, they're asking the court to overturn that decision. This would be the first time a court has ever, in Tennessee, has ever overturned a rule based on a rulemaking form that was approved by the Secretary of State. Second of all, as to the spas, Erlanger's counsel got up here and told you that 3 state courts have said that a spa is a rule under the state UAPA. I'd like to quote for you the Louisiana case. This is Women's and Children's Hospital versus State Department of Health and Hospitals, 2 Southeast Southern 3rd, 397, Penn site 407. This court agrees with the Court of Appeals finding that the rate provided in the state plan is not a rule within the meaning of the Louisiana Administrative Procedures Act. In fact, none of these cases that are cited by Erlanger invalidated the state plan amendment. What those cases said is that the state plan amendment shouldn't be implemented until rulemaking was done. Well, that's exactly what Tenncare did here. They did the state plan amendment, which is expressly what the state statute required them to do. And then they did rulemaking in order to implement that state plan amendment. Second, Your Honors, on the issue of the contract, they keep referring to the term contract, but they don't refer to the term under the state plan. The only contracts that are under the state plan here are the contractor risk agreements, because those are because a state plan has to be transparent for CMS. In fact, when Tenncare submitted State Plan Amendment 7003 to CMS, it actually rejected that estate plan amendment because it said it's not transparent. Here, the rates that are negotiated between providers and MCOs aren't known to anybody. They're not even known to Tenncare unless Tenncare affirmatively asks for them. So that can't be the basis for transparency under the estate plan amendments. Finally, Your Honors, the statute says it has to be budget neutral with respect to what the providers were paid prior to January 1st, 2007. Erlinger does not dispute that its rates are not, and also it is, Tenncare's expert did rebut their statement that capitations would not arise, so that was not an unrebutted point. Thank you, Your Honor.
All right, thank you, General Smith and Mr. Bolian, for your arguments. We will take this matter under advisement. That concludes the morning docket.